Every day in the USA, people find themselves in court.
What is actually scheduled for this afternoon is Elizabeth May Conway, file 241681. It's a resisting obstructing a police officer charge. It's alleged to have occurred on September 16th. Let me find that one, 691. It's alleged that on or about September 16th, you did resist or obstruct Detective Jason Auten of the Sheriff's Department as a fourth habitual offender, making this punishable by, I believe, up to 15 years imprisonment. The prosecutor has agreed to dismiss that charge for a plea to attempting to resist or obstruct a police officer. Attempted resisting obstructing is a misdemeanor. It's punishable by a year and up to a year in jail, fine of up to $2,000. I believe you've been in custody in that matter for $22 days. In addition to that, Mr. Truckee represents you on a number of other cases, and they've tried to resolve all of your cases.
Yeah, but I'd like to work on this one if it's possible.
All right, well, let's talk about that.
I mean, I don't know what fourth time resisting arrest, that's never happened. I've never resisted arrest once.
Say that
I've
again?
never resisted arrest once in my life.
No, it's not a fourth
Or it just
resisting
means a
obstruct,
fourth felony?
fourth felony.
Oh, okay, I understand.
Your other felonies in other counties,
Okay, I thought you were
Oakland,
trying to tell me right
Livingston.
now. That's what you're
Um,
trying to say.
No, it's not a fourth effect.
Yeah, 'cause
but-
I take a plea deal just to get out of jail because I got kids. So yeah.
All right, now let's talk about your other cases, Ms. Conway. You have 4 retail fraud charges pending. And you and I have discussed these. And we were close to resolving them until you realize if you pled not guilty, I'd have to let you out of jail. So you pled not guilty, and after 28 days, I let you out of jail. And then shortly after that, you got rearrested, and now you've been in jail for 22 days. These retail frauds, there's 5 of them. Retail fraud in the second degree. 24843 allegedly occurred on March 7th of 2024. 24842 SM retail fraud, second degree, March 18th, 2024. 24592 retail fraud, second degree. That's a civil infraction under Three Rivers Ordinance. Retail fraud, second degree, March 12th, 24487 SM. And retail fraud, City of Sturgis, September 15th of 2024. So of those 5 of those, the prosecutor has offered that if you plead to 1 retail fraud second degree, they would dismiss all of the other cases. Some of those are ordinance cases. And I don't, did the Sturgis agree with this? There's 3 retail frauds, 2 retail frauds are Sturgis cases.
So maybe one during me calling 911.
I don't
Or else the
represent
story.
Ms. Conway
My-
in any of those.
Yeah, all of the cases that I'm aware of are ones that I looked up with my own eyes in their county. So there might be additional Sturgis that I'm not aware of, but I've got three
Well, there
separate.
are two civil infractions, so
Okay,
you have three and you'll dismiss two if she pleads to one, is that
that's
correct? I believe they're all at Walmart.
I believe you were right.
All three of my files are.
All right. So the plea offer, Ms. Conway, is you plead to one count of attempting to resist or obstruct a police officer, which is a misdemeanor punishable by up to a year in jail, a fine of up to $1,000. And one retail fraud, which will dismiss three or two other retail fraud second degrees. Here, this particular one, you loaded up a cart, put it in a tote, pushed it out of the store, $284 worth of property. And that was alleged to have occurred on March 7th. There were some that preceded that and then some that were after it. So that would be the factual basis for that. Retail fraud second. In 24843 SM. Are you willing to plead to those two misdemeanor offenses?
Not today, that's when I got crowbars, you guys arrested, Cynthia lady, 2 hours arrested her. I got beat with a crowbar during that ticket case.
All right, well, then there's another one. There's two more.
About 3 hours, right? That's the 3 hours incident. And you guys arrested somebody on a possible abduction case. That was me. I was one walking around crutches.
Let's try another one, 842.
Can't do it. I remember getting beat with the crowbar and all that. And I was in the hospital a few times and I got crowbar paperwork.
All right, this one was alleged to be March 18th at the Walmart
It was
store.
Roxanne. It was crowbar.
He's listening to Judge.
In this one, on the video, you went out to general merchandise stores and you stole $264.88 of property. And they identified you from all the other thefts. And I think you went to Oakland County. Are you willing to plead to that one on March 18th?
No.
All right.
Yeah, I keep saying I'll get time served, but I mean,
Alright.
I'm not willing to be not let out of jail today and all that stuff. I'm not willing to transfer to nowhere. I got no warrants right now.
Right.
Try to keep it at that because if I were to be transferred today, I would it'd be very unfortunate because there's a couple of people that are supposed to have warrants for the rest of the day and they still been arrested. A couple of people have been following me to rooms, breaking into my motel room.
All
That's
right.
the main reason why I ended up back at my grandma's Bingaman.
All
So
right.
this
Stop.
lawyer
For,
just said some rude stuff about my cat from my Bingaman to my grandma.
all right.
tell me.
Stop for a minute.
That's why I keep asking, hey, PR bond, PR bond.
I let you out on a PR bond and 5 days later you got arrested all over
Yeah, I
again.
had to call my family member Jason to start this. Which
All
is
right.
the sheriff's county. But by the time I ended up going back to Constantine, Carlisle, which I was supposed to be there anyway, had called 911 for no reason.
All right.
And I got strapped
Just-
to the ground. All I
just-
got asked to was to leave and come back and I couldn't because I had people break into my rooms and already supposed to be in jail right now.
All right. Just stop for a minute. Mr. Marvin, I told you I was writing a comprehensive letter to community mental health regarding the cases that I see in custody that could greatly benefit from mental health services. Ms. Conway is one of them. Your lawyer's trying to get you out of jail. I don't know where you're gonna go. You got caught stealing 5 times in about a month. You were going to enter a plea to one of those charges on a plea agreement until you learned that if you pled not guilty, I'd have to let you out of jail on a 28-day rule. I'd give you a PR bond. So I let you out of jail and those cases were not resolved. Once again, Mr. Marvin agreed to dismiss all the cases if you pled to one. They have you on video 5 times stealing stuff from the Walmart store. And then you have this new resisting and obstructing charge. The offer is to take a plea on the retail fraud charges, give you 28 days in jail, credit 28 days, and plea on the misdemeanor resisting and obstructing charge and get 22 days, credit 22 days, and let you out of jail. But I don't care if you stay in jail because A, you're not willing to admit that you keep stealing all this property, and B, I haven't worked out a plan on what to do with you when you get out of jail. You need some serious mental health treatment. And I was composing a letter to Community Mental Health this morning regarding you and about 8 other people at the jail that could greatly benefit from some services. So this is Mr. Marvin's plea offer: reduce the felony 4th offense habitual to a misdemeanor and let you out of jail, and dispose of at least 3 retail frauds and let you out of jail. But you have to admit that you did something wrong. I mentioned this the last time I saw you. I've watched you disintegrate before my eyes when you first came back to Constantine and you had a case down there. I've watched you dissipate, get sicker or worse. I don't know if it's methamphetamine or fentanyl or both or mental illness, but I'm watching you go downhill and it's not very pleasant to watch. So your lawyer, Mr. Truckee, tried to convince Mr. Marvin to let you get out of jail today. I don't have a plan. I guess I just lay out. I was working on a plan because you need one. So here's the deal. He will dismiss the habitual offender felony charge punishable by up to 15 years in prison if you plead to 1 misdemeanor count of resisting obstructing. He will dismiss 2 other retail frauds that he has the authority to dismiss from Meijer or Walmart if you plead to 1. So if you'd like to do that, we can do it now. If you don't wish to do that, we can set these things for further hearing or a trial if we need to.
So what are you trying to say?
So, boy, I don't know if I can make it any clearer. I'm not sure you're competent.
I'm not sure all the cases behind my head because the Terry Kelly family and the Sodium Waters that Scott Velda have been arrested are behind here on the outside of here. Because what they're trying to do is release of their bond of they put on me. But really one of them raped me in June. So, and they're still not arrested and they're looking for Sodium Waters because he cut my bill cord out in September in a motel room out here. Why do you think I'm back in here?
Well, I think you're in here
I
because
think it's a legal attack that you guys are gonna try and judge me behind their racist criticism. Because they were the ones who were tasing me outside the fucking motel rooms. I had to call my cousin Jason, my mom's cousin Jason Bingham.
Judge, I know nobody wants to be the one to raise competency of my client, but I don't think she can assist in her defense in this case at this point, based on what her statements.
I'm trying to tell you, I would rather prefer work on the first case that we're here for, because my other ones are supposed to be tried out until the 10th, right? What's today's date?
yeah, they're set for a final pretrial. Well, we can do that.
10th. Yeah, like today, what could I plead to right now?
Attempting to resist or obstruct a police
So can
officer.
I leave today if we plead to?
No, I'm gonna leave you in jail if we resolve all the cases, but I'm not gonna make you promises to try to get you to plead. I couldn't have explained it any more clearly than I did. All you're focused on is getting out of jail. I'm
Yeah, because
focused
your
on,
officers are in here in August tasing me while I'm laying there resting while
all
I'm
right,
pregnant.
well, they're not my officers. They're officers here for the county. They're in the executive branch. I'm in the
All right, so
judicial
I'm gonna
branch.
plead guilty to whatever you're saying to, and you're
Um,
gonna take my plea deal? But I'm not gonna say anything further right now, because I'm not gonna be disrespectful. But remember this, do not threaten a bigamist and talk shit about a bigamist attorney. Don't talk about my Catherine Ray bigamist like that again. And I mean it.
Are you talking to me?
Yeah,
Liz?
when you were just out here, you said my grandma bigamist is very rude. You don't even know her. How dare you?
Your Honor, I know that one of the
I
ways
can't
to
believe
raise
it.
competency is by motion, and it's preferred, but at any time, I know I don't have the rule at my fingertips, but at any time during a proceeding, the court or any attorney for that matter can raise the issue.
You agree with Mr. Truckee?
Yeah, and he already did, but I don't have a problem with that. I don't want her to feel compelled to do something.
All right.
And I don't like to raise this issue in these
Well, I'm
cases.
tempted to raise it myself. Miss Conway, we're gonna have you evaluated for competency to see if you're competent to proceed and assist in your proceedings, whether you're able to
I'm gonna
understand.
plead guilty just to get out of here, but I'm gonna.
I-
make sure that
everybody
everybody's
would. Somebody-
arrested that's supposed to be. Most of the
Okay,
people you guys have housed in the jail is because me and my bigamist family members put them there. That's why you have people in here, because they are ready for murder charges on the baby that's cut out of my stomach. Or they attempt to murder me and hire gunsmiths to murder me, or my bigamist family members. Do you understand what I'm saying now? So I'm gonna plead guilty because I'm taking care of it, because I'm on epileptic and medical medications, not psychiatry medications. So please don't talk to me like that. And when they disguise my paperwork at the hospital, it's because I was assaulted sexually or physically, and I don't want my assailants to attack me, which is all the people that should have told them already should be in here, and all the people have been put in, lodged in here. So I'm taking plea deal right now, and then we're gonna make sure you guys take that plea deal. And I want to plead guilty to everything, but make sure, I hope you know when you go home and would sleep at night, how dare you guys? And I'm pleading guilty. Please
All right.
take my plea deal.
I'm not taking your plea deal. You're gonna be evaluated for competency, so please take Miss Conway back. I'm gonna have you examined for competency by the Center for Forensic Psychiatry. See if you're restorable or able to be competent, but I'm not comfortable taking the plea because I don't believe you're competent.
You mean you don't believe I'm
I'm
guilty is what you should say to me,
No,
sir.
I believe there's a highly likelihood that you're guilty, at least of some of this
No,
stuff.
I'm not actually. You're very
All right,
rude
well,
and you should lose your job.
the affidavits show you're on
You should
video
lose
on
your
every one of
job,
these.
is what you should do, Middleton. How
All
dare
right,
you?
bonds
Remember when you
remain the
apologized to
same.
me last time? When you were wrong. That's what you'll be like.
Well, we had hoped, and again, we were just dumping the problem out on the street.
Yeah, exactly.
We've had, we have Miss Anthony, we have Mr. Brown, we have Mr. Valentine, we have Mr. Oswald, we have another guy, the guy that thinks he owns a piece of real estate in the parking lot. They belong somewhere, but it isn't necessarily in jail, but she does continually get charged with stealing stuff. And she's not at all repentant, and she's not focused at all on what the deal is.
And Your Honor, I just like to say I did raised it prior, but the statute causes us defense counsel to be in an untenable position on misdemeanor cases with mentally ill clients, and it ought to be changed.
Well, we do have a felony resisting obstructing charge, but like Mr. Valentine, the misdemeanors will go as well. So we'll prepare an order for competency on all 3 retail frauds and the felony R&O charge. And I said it, I've watched, and you've seen it too. We watched her disintegration. And sometimes you think it's methamphetamine, but she's been in jail for 22 days and she's just as disorganized as she was when I saw her 22 days ago. I let her out of jail on the retail frauds because I could have kept her in for good cause shown. You can exceed the 28-day rule regarding bond and a misdemeanor, but I let her out. And within a very short time, she got arrested again for this. And I suspect if I let her out right now, she'd get rearrested at a short time. We need a better plan other than putting them out on the front steps of the jail. And as we mentioned, and I mentioned in this letter, the jail staff aren't orderlies at a mental hospital. We're running the largest mental institution in St. Joe County at the St. Joe County Jail. There are 88 people in it, and about half of them need significant mental health treatment. And there are about 10 of them who are significantly mentally ill that need to be somewhere. The problem is there is no somewhere. There is no magic place to simply put people. But I'm not confident that she would have been competent to enter such a plea. And so, as you know, Mr. Truckee, then it means they end up in jail for months and months and months and months. A, taking a jail bed. B, not getting any treatment. You'll get this letter that I'm writing where I'm asking Pivotal, who's taken over our jail diversion as of October 1st, to focus on these defendants. There's going to be 8 of them. And one option would be to pursue a commitment and hospitalization short of competency. And we agree she needs competency, but it takes so long to do it.
Well, and it's not right to have somebody ultimately in for retail fraud.
For
To
400,
wait to see if they're competent to plead to something, that's just not America. You don't do that to somebody.
You can exceed your maximum sentence waiting to be competent.
correct.
And that's.
So, and at some point, there's pressure on me to say it's not, they're not equal.
Well, and they're not, but let's say, as we talked about Miss Anthony the other day, or Mr. Brown, I just let them out. Well, then what? You know, she's psychotic and she's standing on the front steps of the jail without a penny in her pocket. We need to have some sort of exit strategy for these people.
I would like to throw a wrench in the next case.
All right, well, let's finish with Ms. Conway. We're going to get a competency evaluation in all those
It
cases.
is my understanding that they have more beds for ladies now.
Then Ben,
And if they're in custody,
they get priority status.
with their evaluation, because they know where they're at.
Now, there's 2 civil infractions still out there. We'll leave those on. Sturgis may simply to dismiss, elect to dismiss those. All right, I was hopeful, but if anything, I think she's gone downhill since the last time I saw her. This is in the matter of Elizabeth May Conway. She has multiple files. File 24842 SM is a retail fraud 2nd degree. File 24843 SM is a retail fraud 2nd degree. File 24847 SM is also a retail fraud 2nd degree. And there's another case, a felony resisting obstructing charge, 241681. Miss Conway's attorney Ross Truckee is here and prosecuting attorney David Marvitt is here. They're both familiar with Miss Conway. She is not here. She is presently in custody at the Sheriff's Department. I asked Mr. Truckee if it would be okay if we did this hearing without her. Mr. Marvin was here with us for the last hearing. We tried to work out a plea here, but it was apparent that she was struggling with some significant mental health issues. She has been to the forensic center and found to be incompetent. She has been in custody now for 50 days. And we have a follow-up order from the Forensic Center. The last time we had her here, she was quite disoriented, and I don't want to bring her onto the camera in that state. According to jail staff, she's still about in the same state. So can we waive her presence here, Mr. Marvin?
Yes.
We received from the Forensic Center a letter dated October 28, 2024, was actually received on November 1st. We're supposed to set these for hearing within 5 days, and so we've done that. It is from Dr. Andrea L. Vanderberg with their opinion. Mr. Truckee, on behalf of your client, may I consider that report?
Yeah, I'd stipulate to the report.
Mr. Marvin, you agree?
I agree.
We've all worked on some cases with Ms. Conley over the past several years, and we've seen her decline. The last hearing was not very good when we ordered this competency evaluation. And according to the report, the doctor has reviewed a number of documents and been in contact with the jail staff. I'm going to go right to the opinion portion of Dr. Carlson's report. Ms. Conway's mental condition was characterized by delusional thought content, often pertaining to physical health conditions that interfered with her ability to have rational conversation. Her thought process was also noted to be disorganized and perseverative about her reported physical health conditions. This is consistent with Mr. Conway's attorney's reports about Ms. Conway's presentation. It is my opinion that Ms. Conway's mental condition impedes her capacity to understand the nature and object of the proceedings against her, as well as her capacity to assist with her defense. It is therefore my opinion that she is incompetent to stand trial. In summary, giving the weight of the available information, it is my opinion that Ms. Conway is not competent to stand trial on the pending charges at this time. While it is my opinion that Ms. Conway was competent to stand trial, it is also my opinion there is a likelihood that Ms. Conway can be restored to competency within the time period allotted by the statute. 15 months for the felony and 4 months for the misdemeanors. If she was provided a structured inpatient hospital setting. Based on my clinical experience, people with delusional thought content similar to Ms. Conway's tend to respond to treatment in the time period allotted by statute. Thus, it is my opinion that it's likely she would be restored to competency if such treatment were provided. So the court is prepared to enter an order finding the defendant is incompetent and shall be referred to the Center for Forensic Psychiatry for treatment to attempt to restore competence. As we often know in these cases, sometimes it's hard to determine where addiction ends and mental health starts. But she's been in custody for 50 days and her condition has, if anything, probably deteriorated. And they think with a course of conduct, medication, and treatment, she can be restored to competence. As we all know, the problem is going to take a while. So based on the stipulation to the report and the previous knowledge we have about this defendant, I'm going to find the defendant is incompetent and I will do an order for further treatment. Anybody want to add anything? I did write a letter. I think I shared it with each of you to Pivotal we've got a number of people in the jail that belong somewhere other than jail, and she's one of them. But there we are. I don't know if I never heard anything back, but we lost our liaison and they've got new people and I'm not sure how well we're doing so far, but anyway. She is presently incompetent. We saw it ourselves. So let's get some treatment and see if she can be restored to competence so we can resolve these cases. All right, thank you all.
Thank you, Judge.